Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and I hope everybody is doing well this evening or today. Not sure what time this video is going to post, but if you guys remember, I told you that Judge Donnelly would be rolling out these documents explaining the rulings that she made pre-trial as well as during the trial. And so I already read her reasoning for not dismissing the case. And last week she posted her responses to some of the motions in limine. And so I am going to read this document to you guys as she has stated her opinions. And I believe we'll see a couple more come out. I know in the document that I read to you guys last week, I think it was last week or the week before last, there were some, if you guys remember, I was telling you all during the trial that the Calvin Scholar, attorney Calvin Scholar, kept filing all these motions and he was filing them under seal. So we don't know what those motions were about or what they contain. And because those motions were under seal and they remain under seal, Judge Donnelly basically denied all of them. I think it was about maybe 5 of them. She denied them as being moot, meaning that there was no purpose or no point to the motions that he was filing because the issue may have already been resolved. The person he may have been talking about wasn't going to be called to the witness stand, or the evidence he was trying to dispute, the government had decided not to introduce that evidence. And so she dismissed those motions, what is called as it's a moot issue. There's no need in taking it any further. And then some of the things that he was requesting also could have something to do with the motions that Thomas Farinella had submitted that she was denying anyway. So she just didn't feel the need to address his motions and, provide a formal statement. So those are some of the reasons that a motion or request would be denied as a moot point. So I'm going to go ahead and read this to you all. So it says, Ann M. Donnelly, United States District Judge. The defendant was charged with racketeering in violation of 18 United States Code, Section 1962C and 1963. 3 counts of Mann Act transportation to engage in illegal activity in violation of 18 United States Code 2421A. 3 counts of Mann Act coercion and enticement to engage in illegal activity in violation of 18 United States Code Section 2422A. 1 count of Mann Act coercion of a minor to engage in illegal activity in violation of 18 United States Code Section 2422B. And then also Section 2223A, which is the transportation of a minor with intent to engage in illegal activity in violation of the United States Code. And for those of you who are new to my channel, when I'm reading these motions, there are certain words that I don't say. So like basically where it says, where I'm saying illegal activity, they're actually talking about sex, okay? So I don't say that word because YouTube is real funny about how they flag when they send their bots through to listen to the videos. There are certain words that they're looking for. So she goes on to say, on September 27, 2021, the jury convicted the defendant of all counts. Prior to trial, the government filed motions in limine which the defendant generally opposed. And then she tells you the reference numbers of where you can find these. And so they were basically in documents 121, 133, 135, 136, 137, 145, 146, and 151. At the final pretrial conference on August 3rd, 2021, and before opening arguments on August 18th, 2021, I ruled on most of these requests, reserving decision on 2 of them. And then she says, on September 27, 2021, the jury delivered this verdict, finding the defendant guilty of each of the 9 counts charged. This opinion explains the rationale for these rulings. So then she gives the legal standard, and she says the purpose of an in limine motion is to aid the trial process by enabling the court to rule in advance of trial on the relevance of certain forecasted evidence as to issues that are definitely set for trial without lengthy argument at or interruption of the trial. McLeod versus Alano, and this is a case out of the Eastern District of New York, April 28, 2021. And so she's quoting someone named Polari versus DeFario, and this was a case heard in 1996 by the Second Circuit of Appeal. And it says, in limine rulings are subject to change when the case unfolds. And then she has quoting Lucy versus United States, which was a case from 1984. So under the federal rules of evidence, evidence is admissible only if it is relevant. Federal Rules of Evidence 402, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action, and that's from Federal Rules of Evidence 401. Under Rule 403, evidence that is relevant may nevertheless be excluded if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. And that came from the Federal Rules of Evidence, Section 403. And then she says, in applying Rule 403, the court conscientiously balances the proffered evidence's probative value with the risk of enumerated dangers, which is a quote from United States versus Awadallah, which was heard by the Second Circuit in 2006. And so I'm going to go back up and read a note that she had written. Let's see, let's go back up here, because she has a lot of lengthy notes in this. So it says, Rule 404B3 requires the government to provide reasonable notice of any Rule 404B evidence before trial so that the defendant has a fair opportunity to meet it. The written notice must articulate the permitted purpose for which the government intends to offer the evidence and the reasoning that supports the purpose. On July 23, 2021, the government filed its motions in limine outlining evidence it sought to admit at trial, including under Rule 404B, and for each request, the permitted purpose for the evidence was the corresponding reasoning. And then she cites the documents 133 and 135. And when I'm giving you these document numbers, this is where you can find, so like if you go into Pacer and you look up this case, then you would look for these document numbers to find what she's talking about. And then the note goes on to say, thus Thus, the government, then it scrolls down to the bottom of the next page, met the notice requirement of Rule 404B. See Federal Rules of Evidence 404B, Advisory Committee's Note to 2020 Amendment. In many cases, notice is provided when the government moves in limine for an advance ruling on the admissibility of Rule 404B evidence. Nevertheless, based on the defendant's representation at the final pretrial conference that he needed more time to respond to certain requests, the court reserved decision on those requests and directed the parties to submit supplemental briefing. Notably, and as explained below, almost all the evidence the government sought to admit was relevant to proving the enterprise and its structure rather than other acts' evidence. And then she had a second note that says the government moved to admit some evidence that it did not ultimately offer. Accordingly, I do not discuss those rulings. And so then we're going to pick up where she left off here. Okay, so we're going to pick up on her explanation for why she's doing this. And every now and then, if there's notes at the bottom of the page explaining some of the things that she's written in her ruling, then I'll stop and read those notes, and then we'll go back and pick up. And so we're picking back up after the Adewale case that I was referring to a few minutes ago. So she says, as a general matter, evidence of a defendant's prior crimes or bad acts is not admissible to prove propensity. Federal Rules of Evidence 404. That evidence, however, may be admissible for other purposes, including to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Federal Rule Evidence 404B2, the Second Circuit follows the inclusionary approach, which admits all other act evidence that does not serve the sole purpose of showing the defendant's bad character and that is neither overly prejudicial nor irrelevant. United States versus Banyan, which was heard in the Second Circuit in 2021, summary order quoting United States versus Curley, which was heard by the Second Circuit in 2011. Moreover, Rule 404B does not preclude direct evidence of the existence of a RICO enterprise, evidence that is inextricably intertwined with evidence of a charged offense, or evidence that provides necessary background in the charged offenses. United States versus Rivera, which was heard by the Eastern District of New York, April 22nd, 2015. And then she's quoting United States versus Baez, which was heard by the Second Circuit in 2007. And it stated, when a defendant has been charged with racketeering offenses, it is well settled that the government may introduce evidence of uncharged offenses to establish the existence of the criminal enterprise. And then in the United States versus Carboni, which was heard by the Second Circuit in 2000, quoting United States versus Gonzalez, which was heard in the Second Circuit also in 1997, evidence of uncharged criminal activity is not considered other crimes evidence under Rule 404B if it arose out of the same transaction or series interactions as the charged offense. It is inextricably intertwined with the evidence regarding the charged offense, or if it is necessary to complete the story of the crime on trial. So, she's basically explaining why she let them bring all them people in there with that hearsay evidence, telling their stories about what allegedly happened without any, rape kits, any medical records, any police reports, any eyewitnesses to confirm that the things did or did not happen. For example, the chick that came up there, I think she was one of the uncharged people, but her name was Addie, and she claimed that she had gone to this concert. Her mom had gotten tickets for her and her best friends to attend a festival where R. Kelly was performing down in Miami. And she had this program and a ticket stub with a number that was supposed to have been a room number. We didn't hear from the best friend. We didn't hear from the lady from the radio. I think she might have been the one where the lady may have passed away who worked at the radio station. But where's her mother to talk about, yeah, I helped her get to this concert. Do you know that you can buy these old programs, memorabilia, off of the internet, off of eBay and all these different websites? So that girl, the government may have gotten that program and that ticket and just told that girl, whoever she was, because we still don't know who she is. We don't know who a lot of these people are that got up there and testified and don't know if their stories are true or not. But in any event, Judge Donnelly is explaining why she allowed these people to get up there without any proof whatsoever that what they are claiming actually happened. So here's a note at the bottom of the page before I continue on. And it says that the standard of proof under Rule 404B is whether a jury could reasonably conclude by a preponderance of the evidence that the act occurred and that the defendant was the actor. And then Boyce versus Weber from the Southern District of New York, July 7, 2021, quoting United States versus Gillen, which was a case heard in the Second Circuit of 1992. And basically, you notice she's using these recent cases. So they are basically letting this become a standard where they're just bringing in people, allowing them to say whatever they want to say without any proof in order to find people guilty. So continuing on in her ruling, it says Rule 413 permits certain propensity evidence in the specific context of assault cases. In a criminal case in which a defendant is accused of assault, the court may admit evidence that the defendant committed any other assault, so long as the evidence is relevant. But y'all didn't have no evidence, girl. And so that's from Federal Rules of Evidence 413A. And then she says under Rule 412, evidence offered to prove that a victim engaged in other behavior or evidence offered to prove a victim's sexual predisposition generally is barred. So the person could be in a hole from hell. They're not allowed, the defense is not allowed to get that information or produce that information that, hey, this person was already sexually active. This person has a history of sleeping with men and then extorting them afterwards. So none of that could come into evidence, but they are able to just bring these people in with no proof that anything actually happened between them and the defendant. So then she says, Federal Rule of Evidence 412A, the rule identifies 3 specified exceptions. Evidence of specific instances of a victim's sexual behavior if offered to prove that someone other than the defendant was the source of semen injury or other physical evidence. 2, evidence of specific instances of a victim's sexual behavior with respect to the person accused of sexual misconduct is offered by the defendant to prove consent or if offered by the prosecutor. And 3, evidence whose exclusion would violate the defendant's constitutional rights. Federal Rules of Evidence 412B1. If the defendant intends to offer Rule 412B evidence, he must move to do so at least 14 days before trial, unless the court for good cause sets a different schedule. And the motion must specifically describe the evidence and state the purpose for which it is to be offered. Federal Rules of Evidence 412C. The defendant also must serve this motion on all parties and give notice to the victim. Finally, hearsay, an out-of-court statement offered for the truth of the matter it asserts, is inadmissible unless it falls within an enumerated carve-out of exception. Federal Rule of Evidence 801, 802, and 803. So, discussion. 1. Request to admit certain evidence. A. Sexual contact with Jane Doe number 1 in 1994. So we know Jane Doe number 1 was Aaliyah. The government moved to admit evidence that the defendant had contact with Jane Doe number 1 in 1994 when she was a minor. The motion was granted. The Racketeering Act 1, the defendant was charged with bribing a public employee. According to the government, the defendant and his associates bribed a public official so that the defendant could marry Jane Doe number 1 as part of an effort to conceal the fact that he had sexual contact with her when she was 15. Evidence of the defendant's sexual contact with Jane Doe number 1 was inextricably intertwined with the evidence of the bribery and established the motive for it. The evidence was therefore relevant and not barred by Rule 404B, nor was it barred by Rule 403. It was relevant and probative for the reasons just discussed and was no more inflammatory than the charged offenses. United States versus Rivera, which was out of the Eastern District of New York, April 22nd, 2015. Quoting United States versus Levada, which was heard in the 2nd District in 1999. Evidence shall be excluded as unfairly prejudicial when it is more inflammatory than the charged crime. And so Judge Donnelly is saying that it was not, and therefore she did not exclude it. So then B, contact with Jane Doe number 7, a minor, in 1991. Child, who did we say Jane Doe number 7 was? Like, all these people are running together. Jane Doe number 7 was that lying behind Javante Cunningham. Okay, the government moved to admit evidence that the defendant had contact with Jane Doe number 7 when she was a minor, and that Jane Doe number 7 observed the defendant having contact with Jane Doe number 1. In supplemental briefing on this request, the defendant argued that the evidence was needlessly cumulative. On August 18, 2021, before opening arguments, I granted the request in part and denied the request in part. I found that evidence that Jane Doe number 7 witnessed contact between the defendant and Jane Doe number 1 was admissible for the same reasons that evidence of the defendant's contact with Jane Doe number 1 was admissible. I also found that evidence of the defendant's contact with Jane Doe number 7 was not admissible because it took place before the enterprise began and was needlessly cumulative. Now, do I need to go back and okay, maybe Javante didn't talk about, maybe she didn't talk about when they supposedly was going into the apartment. I have to go back and read her testimony because I thought she told that story during her testimony. I have to go back and read that. But basically, Judge Donnelly is saying that she didn't allow her to talk about any contact that she had with Kelly back in 1991 because it was before the government claimed that the enterprise took place. And so it wasn't relevant. And then on September, and then also she had no proof that she saw him with. So that's, to me, that's hearsay if there was no proof that she actually saw him and Aaliyah doing anything. So I didn't understand why that was allowed. Because to me, that was just plain and simple spreading rumors and spreading lies. So on September 4th, 2021, the government renewed its request to admit evidence of defendant's contact with Jane Doe number 7, arguing that it was inextricably intertwined with the evidence the court had ruled admissible, and made an additional proffer that when the defendant had contact with Jane Doe number 7 and other minors, his associates knew what the defendant was doing. The defendant opposed. On September 9, 2019, I granted the government's request. Okay, I thought I heard that girl, I read that girl told that story to the jury. So the government's additional proffer made clear that the evidence was inextricably intertwined with Jane Doe number 7's account of witnessing sexual contact between the defendant and Jane Doe number 1, and was additional relevant evidence of the enterprise means and methods. Boyle versus United States 556. Oh, anyway, it was a case in 2009. I'm not going to read that whole case number. An association, in fact, enterprise must have a purpose and relationships among those associated with the enterprise. Accordingly, the evidence was neither unduly prejudicial nor cumulative. All right, Anne. So here's another note. It says there was no need for a further evidentiary hearing. The parties briefed these issues and had an opportunity to make their arguments during the August 3rd, 2021 pretrial conference. Moreover, as stated above, rulings on motions in limine are subject to change as a trial unfolds. And then C, sexual contact with Jane Doe number 8 in 1994. The government moved to admit evidence that the defendant had contact with Jane Doe number 8 in 1994 when she was a minor. Specifically, the government sought to present evidence that Jane Doe number 8 was at the defendant's concert and that one of the defendant's associates directed her backstage where she had contact with the defendant. This request was granted, and I think Jane Doe number 8 was Addie. The evidence was direct evidence of the enterprise and its means and methods to establish an association, in fact, enterprise within the meaning of 18 United States Code 1961-4. The government was required to prove beyond a reasonable doubt, among other things, a purpose and relationships among those associated with the enterprise. The indictment charged the defendant with leading an enterprise that included the defendant, his entourage, and others, and charged that the purpose of the enterprise was to recruit women. Hold on, guys, I lost my place. Okay, sorry about that. Okay, was to recruit women and girls to engage in illegal activity with the defendant, including by recruiting women and girls at concerts. Evidence of the defendant's encounter with Jane Doe number 8 was probative of the existence of the enterprise and the way it operated. The girl produced a program and a ticket. How was that evidence of an enterprise and how the enterprise was operating? And then she claims it was no more inflammatory than the charged offenses and did not raise other Rule 403 concerns. D. Contact with Jane Doe number 9, a minor, in 1995. The government moved to admit evidence that the defendant had contact with Jane Doe number 9 in 1995 when she was a minor. In particular, the government sought to introduce evidence that the defendant began a relationship with Jane Doe number 9 when she was 17 years old, that the defendant slapped her when she laughed at another man's joke, that she contracted herpes from the defendant, and that she told him that he had given her herpes. In supplemental briefing, the defendant argued that this evidence was needlessly cumulative. The request was granted in part and denied in part. Evidence that Jane Doe number 9 had a sexual relationship with the defendant in 1995, contracted herpes with him, and disclosed that she had herpes to him, was admissible to show that the defendant knew he had herpes, which was charged in Racketeering Acts 8, 12, and 14, as well as in counts 6 through 9. And I think Jane Doe number 9 was the one who, I can't remember her name, but she sued him, and then even after she sued him, she tried to have a relationship with him, but he didn't want anything to do with her. And then I think she's also the one that had the friend that passed away. So then it says, let's see, which was charged in Racketeering Acts 8, 12, and 14, as well as in counts 6 through 9. The evidence was therefore relevant. The evidence was not unduly prejudicial. It was not more sensational than the charged offense, and it did not raise other Rule 403 concerns. Evidence that the defendant slapped Jane Doe number 9 when she laughed at another man's joke, although relevant, was needlessly cumulative. So I guess they didn't let them talk about the slapping part. E. Exposure of Jane Doe number 11 to an STD in 2001. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 11 without disclosing that he had herpes. That Jane Doe number 11 told the defendant she believed she contracted herpes from him in 2001, and that Jane Doe number 11 entered a financial settlement with the defendant. In supplemental briefing on this request, the defendant argued that evidence of the settlement should be excluded because the jury would interpret it inappropriately as a concession of guilt, and because allowing the settlement agreement into evidence would send a chilling effect to any future settlements. Citing Rule 701C, which prohibits a lay witness from testifying based on scientific, technical, or other specialized knowledge within the scope of Rule 702. The defendant also argued that Jane Doe number 11 should not be permitted to testify that she contracted herpes from the defendant. The government responded that the settlement agreement was admissible under Rule 408. The government's request was granted. Evidence that Jane Doe number 11 told the defendant that she believed she contracted herpes from him was relevant. It was evidence that he knew he had herpes, which the government was required to establish beyond a reasonable doubt to prove Racketeering Acts 8, 12, and 14, as well as counts 6 through 9. The defendant's Rule 701 argument was unavailing. Jane Doe number 11's testimony about her interactions and communications with the defendant and about her own medical status is not expertise within the meaning of Rule 702. Jane Doe number 11's settlement agreement was also admissible. It was evidence of the enterprise and its means and methods. In particular, the efforts the enterprise undertook to conceal and perpetuate the enterprise, nor was it precluded by Rule 408. While evidence of a settlement agreement to prove the validity or amount of a disputed claim is not admissible, the court may admit this evidence for another purpose. In this case, the agreement was admissible for a purpose other than to prove or disprove the validity of the claims that the agreements was meant to settle. Westside Winery Incorporated versus SMT Acquisitions LLC, which was a case in the Eastern District of New York, November 5th, 2020, quoting in regards to subpoena issued into commodity futures trading, and that was something from 2005. As discussed above, the agreement demonstrated the defendant's efforts to conceal the enterprise and thus was admissible. Okay, so Jane Doe number 11 was the girl whose friend passed away. I think she went by Kate. Yeah, I think she went by Kate. So now I can't remember who Jane Doe number 9 was. And Jane Doe number 9 is somebody we've talked about a lot. And if you're new to listening to these videos, if you go under my playlist, R. Kelly series, you can actually listen to the transcripts from all the people that testified in the case. Well, most of them, because before I could get to finishing the transcripts, they came back with the verdict. The case ended and they came back with the verdict, so I didn't read some of the later testimony. I think Jane Doe number 9, I'm not even going to try and guess who these people are, but y'all that have been following my videos, you remember who these people are, and those who haven't, go back and check the prior videos and you can figure out who these people are. So then there was a note at the bottom of this page, and it says, moreover, it is not at all clear that the settlement agreement was legal or enforceable. See Beth Israel Medical Center versus Horizon Blue Cross and Blue Shield of New Jersey, which was heard by the Second Circuit in 2006. And it says contracts for an illegal purpose or contrary to public policy are not enforceable. Cosby versus American Media Incorporated, which was heard in Pennsylvania in 2016. Finding settlement agreement unenforceable as volatile of public policy to the extent it prevented parties from cooperating with the criminal investigation. And you guys know that was the Andrea Constead and Bill Cosby case, which allowed them to prosecute him, and his conviction was eventually overturned. So then she moves on to F, and it says sexual contact with Jane Doe number 13 in 2006. The government moved to admit evidence that the defendant had contact with Jane Doe number 13 in 2006 when she was a minor. According to the government, the defendant met Jane Doe number 13 at a concert when she was 15. He began a relationship with her and directed his associates to arrange Jane Doe number 13's travel to visit him in Chicago. The request was granted. The proposed evidence, I just don't understand how a 15-year-old just hopped on a plane and flew to Chicago to be with a grown-ass man. But anyway, the proposed evidence was direct evidence of the enterprise, its purpose and its means and methods. It was therefore relevant and not barred by Rule 404B. The proposed evidence was admissible under Rule 403. It was probative of the enterprise and no more inflammatory than the charged offenses. So it seems like that's going to be her response to everything. So G, contact with John Doe number 1, and you guys know that was the Richard R. line, who was basically testifying, hoping to get a deal, get a lesser sentence on his plea deal for trying to bribe Ariel, and he was supposed to be sentenced in June. And then they pushed it out to October, and now they have pushed it into next year sometime that he will eventually get his sentence. And you know, he did not give what the government wanted him to give in his testimony. And so there were rumors going around that he may not get, I think he was looking for like 2 years probation or some crap like that. But they're saying that he may get a stiffer sentence, but I am going to say that that is probably not the case, since they did find Mr. Kelly guilty on all charges, that he'll probably still get the lesser sentence, or they might just drop the charges against him, since they keep pushing it out and thinking that we're going to forget about it. So it goes on to say the government moved to admit evidence that the defendant had contact with Jane Doe number 1 in 2006 when Jane Doe number 1 was a minor. And we need to stop saying minor and say how old these people were. Like, he was allegedly 17 years old at the time, which my understanding in Chicago is the legal age of consent. So the government sought to present evidence that the defendant promised to help John Doe number 1 with his musical career. And you guys remember that was a common theme. All these people were seeking out R. Kelly, or were happy to meet him, because they thought they had a future in the music industry, and it doesn't appear that any of them did. Whether they met him or not, they weren't going anywhere. And so it says that they began a relationship and directed him to engage in filmed encounters with others. The request was granted. The evidence was direct evidence of the enterprise's purposes as well as its means and methods. The indictment charged, among other things, that one of the purposes of the enterprise was to produce porn, including CP. Thus, the evidence was relevant and not barred by Rule 404B. Finally, the evidence was not unduly, was not unduly prejudicial. It was no more inflammatory than the charged offenses and did not raise other Rule 403 concerns. Now, I want to know what evidence is she talking about, because he got on the witness stand and said that R. Kelly filmed them in 2007 having SCX with an iPad, and it was later revealed that the iPad came out years later. So I'm not sure what evidence is Judge Ann talking about here. And see, there was a note at the bottom of that page that says, if the compromise agreement is itself illegal, evidence of this is admissible. Okay, so she's basically making a note based on what she ruled earlier about the settlement agreements, that they're not legally binding documents and therefore they are not enforceable and they can be presented as evidence. So H, threats towards employee number 1 and settlement payment to Jane Doe number 15. The government moved to admit evidence that the defendant threatened employee number 1, a talent manager who we know is Cheryl Mike, and that he entered into a settlement agreement with Jane Doe number 15. In particular, the government alleged that the defendant met Jane Doe number 15 through her talent manager, and Jane Doe number 15 was Precious Way, who refused to testify, refused to talk to investigators. So I'm not sure how any information about her is admissible when she wouldn't even sit down and have a conversation with them. So it says employee number 1, when Jane Doe number 5 was 17, and that the defendant promised to act as a mentor to Jane Doe number 15 in the music industry. The government also moved to introduce evidence that Jane Doe number 15 subsequently accused the defendant of abusing her, that the defendant threatened and intimidated employee number 1, causing her to sign an affidavit falsely stating that she did not witness the defendant do anything inappropriate to Jane Doe number 15, and that the defendant reached a financial settlement with Jane Doe number 15. In supplemental briefing, the defendant argued that the evidence was needlessly cumulative. The government's request was granted. Okay, so seems like the defense wasn't filing good enough motions. I probably could have wrote some motions that would have got approved, and I don't even have a law degree. And I may have said Jane Doe number 5 earlier when reading that paragraph, but it's Jane Doe number 15, which was Precious Way, who refused to even meet with investigators. So I'm not sure how Donnelly is granting this motion when the person, I don't understand. Like, there's no testimony from Precious Way and no statements from her that the government could have introduced. That I don't get it, y'all. But I think the new attorney, Jennifer Bonjon, she gonna have a good time with this. Okay, so she says the evidence showed the enterprise's means and methods. Specifically, it showed the enterprise's efforts to perpetuate and conceal the enterprise. Thus, the evidence was relevant and not barred by Rule 404B, nor was it unduly prejudicial because it was no more inflammatory than the charged offense, which is her answer to everything. So abuse of Jane Doe number 18 from 2016 to 2017, and I believe number 18 is Hallie Calhoun, who did testify. The government moved to admit evidence that the defendant abused Jane Doe number 18 psychologically and physically. According to the government, Jane Doe number 18 began a relationship with the defendant after one of his associates approached her at a concert. The defendant then subjected her to his rules and punished her, including physically, when he perceived that she had broken them, directed her to write letters containing embarrassing false statements about herself, and directed her to have sex with him and others, which was filmed. The request was granted. And says that this direct evidence of the enterprise, its purposes and its means and methods, it showed the defendant's control over his associates and the victims. She's basically saying the same thing. It also was inextricably intertwined with evidence of the charged offenses involving Jane Doe number 5. The proposed evidence was also admissible under Rule 413 and was relevant to the charged assaults of Jane Doe number 4, Jane Doe number 5, and Jane Doe number 6, who none of them were assaulted. Like, they're just writing stuff and making stuff up because none of them heifers claimed that they were sexually assaulted. They all willingly had sex with this man, pursued this man, got into a relationship with this man under their own free will. So how is that sexual assault? And then we know he didn't even have sex with Jane Doe number 4 because that is Cuckoo for Cocoa Puffs, Geronda Pace. And we know he never had sex with her. Oh my God. So moreover, the evidence was not unduly prejudicial, blah, 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 or otherwise excludable under Rule 403 because it was no more inflammatory than the charged offenses. J. Threats towards Jane Doe number 6 in 2018 and 2019. You guys know that is Faith Rogers. The government moved to admit evidence that the defendant and his associates threatened Jane Doe number 6 in an effort to convince her to stop speaking publicly about the defendant and to drop a lawsuit she had filed against him. So these so-called associates did not work for him, but we know it was Cash Jones and Don Russell, who were acting on their own accord, who admit that they were acting on their own accord, and who were not called as witnesses in the case to be questioned about these allegations that were being made. Now, they did have evidence. They did have like the text messages, and they did have where Cash Jones was in New York and her and Don Russell scheduled a meeting with Faith and her mom. But R. Kelly was nowhere to be found in any of this. Now, they did have information, or they had text messages where he had sent Don Russell's mother, June, some pictures of Faith Rogers, but they were pictures not that R. Kelly had taken of Faith Rogers, but they were pictures that Faith Rogers had taken of herself and sent to him, and then he sent them to Don Russell's mom because Don Russell's mom was writing a letter to the then attorney, the Lydia Agu lady, basically asking them, it was like a cease and desist letter, and they included these pictures in the letter. But June Barrett was not a part of the indictment. June Barrett has never been arrested. Cash Jones has never been arrested as part of the enterprise for making threats and all of this other stuff. But they have Don Russell, who was arrested. But you clearly had information in the trial come out that both Cash and Don Russell's mom, June, were just as much involved in Don Russell's plot to threaten or intimidate or do this cease and desist letter to Faith Jones to get her to drop this lawsuit. Why weren't they part of the indictment? Why weren't they charged? I don't understand that. I really, really don't. But anyway, we're going to keep on reading here. So it says, this was direct evidence of the enterprise. Okay, the request was granted. And then she says, this was direct evidence of the enterprise and its means and methods, including the use of threats and blackmail to conceal and perpetuate the enterprise. It therefore was relevant and not improper Rule 404B evidence, nor was it unduly prejudicial. It was no more sensational than the charged offenses or otherwise excludable under Rule 403. So K, alleged threats to Jane Doe number 19 in 2018. The government moved to admit evidence that the defendant directed a former girlfriend, Jane Doe number 19, to sign a non-disclosure agreement and to write text messages containing embarrassing false statements about herself and that the defendant made veiled threats to her and her family. The request was denied. Okay, finally, a win. Okay, so it says the proposed evidence was needlessly cumulative. There was other admissible evidence of the enterprise's means and methods. The government did not explain how this conduct related to the enterprise. And let me stick a pin here and go back to Hallie Calhoun's testimony. There was some confusion because after the verdict came down, there were 3 videos shown to the media, and one of the videos was of Hallie Calhoun where he was walking her with like a dog chain, and I can't think of the music video that was in. But, people do freaky, nasty stuff like that. And then I think he spanked her, and then she was, saying, "Oh, please don't hit me. Stop hitting me like that," which we know is part of that. What is it? BSDM or whatever. Just freaky, nasty stuff that people be doing and they get pleasure out of. But anyway, they showed that video to the media, but I don't recall them showing that video during the trial. Maybe they did, and I just skipped over it. But that was one of 3 videos that we know that they did show during the trial. There wasn't no hundreds and hundreds of devices and all that stuff. 100 devices, as people was claiming, that had all this porn and other stuff on it. None of that was revealed in the case. So then she moves on to bribery of a Cook County clerk in 2019. The government moved to admit evidence of a conversation between the defendant and his crisis manager, who we know was Daryl Johnson, after the release of a television show about the defendant and while law enforcement was investigating the defendant. According to the government, the crisis manager told the defendant that he had 2 people who knew a lot and that the defendant should figure out what you can do for them. The defendant responded, "What you do, man, is write something on a piece of paper and give me what I should tip the bailiff, what I should tip the valet. Like when my uncle come up here and say, 'Rob, the valet guy, he parked the car over there.' I say, 'So what should I give him?' He say, 'Well, $20, $30. I give him $30. So what I'm saying is, I don't know that number." The crisis manager also told the defendant that he had paid a clerk in Cook County $2,500 and given the clerk a burner phone to communicate information about the ongoing investigations. The crisis manager said, "That's done. You don't know nothing," to which the defendant replied, "Exactly." According to the government, this conversation was evidence of the defendant's willingness to bribe someone and therefore was probative of the continuity of the enterprise. The request was denied. So that's what the second denial was, sort of like the third or fourth denial, because she did have some partial denials earlier, but this is the second straight up denial. And she says that the proposed evidence was marginally relevant because it went to the means and methods the enterprise undertook to conceal and perpetuate itself, but it was too tenuous to be admitted. While the evidence demonstrated the defendant's willingness to bribe someone, there was no proof that he actually followed through. For this reason, the proposed evidence had the potential to confuse the jury and was not admissible. Wouldn't that be the same as with Demetrius Smith getting up there saying that he knew nothing about them bribing any officials, that it was not his idea to bribe anyone to get the fake ID for Aaliyah? Wouldn't that same rule apply? But according to Judge Donnelly, it did not. So then M, the defendant's 2008 state criminal case. The government moved to admit evidence that the defendant was tried on CP charges in 2008 in Cook County, Illinois, and that he tried to influence one of the jurors. That request was denied. The evidence was not relevant to the alleged enterprise. Moreover, it was impermissible propensity evidence and cast the defendant as a long-time subject of suspicion. Oh, so you denied that because you didn't want to show that the government had been investigating him ever since he was acquitted in 2008. Okay, Judge, we got you. So then we move on to N. The defendant's efforts to obtain CP. The government moved to admit evidence that Jane Doe number 5 obtained CP for the defendant at his direction. The request was denied, and you guys know Jane Doe number 5 is Ariel Clary, and she claimed that she had looked up some CP boy-on-boy action going on an iPad for Mr. Kelly, okay? And the judge was like, no, sis, try again. And so it says, this evidence was not admissible. It was not clearly relevant. The government did not demonstrate that the allegation related to the enterprise or its ends. Moreover, the evidence was unduly prejudicial and potentially confusing, especially given the government's concession that the people in the recording at issue may not be children, that they were actually adults pretending to be. O. Audio recordings of the defendant's physical abuse and threats. The government moved to admit 2 recordings in which the defendant yelled at and physically assaulted women, including Jane Doe number 20. In one of the recordings, the defendant berated and threatened Jane Doe number 20. The request was granted. And so that was the video with Lisa Van Allen. And you guys remember Lisa Van Allen claimed that she was having a panic attack and she couldn't show up and get up on that witness stand and explain to us what was going on in that video or give context. So basically they showed this video without any context, and it was unable to be refuted, as to what was going on, because none of the people in the video was there to testify. And so it was Lisa Van Allen and some other people that was in the room. And then there were sound guys, technicians and stuff that were also there when he was cursing Lisa Van Allen out. And who hasn't cut somebody out for stealing from them? Because remember, she had stolen the Rolex watch and all of that good stuff. So I don't understand why that was granted, Judge Ann. But she says that this was direct evidence of the enterprise, its purposes, means, and methods, and defendant's participation in the enterprise. Girl, please. The proposed evidence demonstrated the defendant's control over victims of the enterprise and others as alleged in the indictment. Oh, child, the evidence was no more inflammatory or sensational than the charged offenses, as it was alleged to depict conduct similar to the conduct. Y'all know I done lost my place again. Okay, sorry about that. The evidence was no more inflammatory or sensational than the charged offenses, as it was alleged to depict conduct similar to the conduct charged. The proposed evidence was not otherwise excludable. Okay, at what point was he charged with yelling at somebody for, which charge was that? Yelling at somebody for stealing from him. I don't recall reading about that charge. So I'm not sure how that was related. But anyway, P. Ariel Clary's text messages. The government moved to admit text messages that Ariel Clary sent to her mother and friends. Because the admissibility of the text turned on trial testimony, I reserved decision for trial. At trial, the text messages were admitted without objection. And so they're saying that the defense didn't object to the text messages. Q. Employees' text messages. The government moved to admit text messages of 2 of the defendant's employees that recount, among other things, their observations of the defendant's interactions with them and with others. Because the admissibility of these texts turned on trial testimony, I reserved decision for trial. At trial, the text messages were admitted without objection. Let's see. Defendant's text messages. The government moved to admit the defendant's text messages that his world was huge and had many rules. The request was granted. It was admissible as the statement of a party opponent and relevant to the enterprise's means and methods. It was not unduly prejudicial and did not otherwise violate Rule 403. S. Electronic note. The government moved to admit evidence of an electronic note that Jane Doe number 5 wrote on a cell phone in August 2018 containing a list of the defendant's rules. The request was granted. The note was not hearsay. Rather, it was offered to show the existence of the list and that Ariel Clary authored it. It was also relevant. It went to the enterprise's means and methods and the control that the defendant exercised over Ariel Clary. As Ariel Clary testified, she wrote the note. Thus, the note was admissible to show that she authored the list. The evidence was not unduly prejudicial, nor did it otherwise raise other Rule 403 concerns, which it should have, because if she admitted she wrote the note, where was the proof that he made her write the note? But anyway, T. Newspaper articles. The government moved to admit certain newspaper articles as ancient documents pursuant to Federal Rules of Evidence 803-16. The article showed that the defendant performed in Macon, Georgia on August 30th, 1994, in Albany, Georgia on August 31st, 1994, and in Miami, Florida on September 2nd, 1994. The request was granted with the acknowledgement that the ruling could be obviated by a stipulation by the parties. Ultimately, the government admitted a heavily redacted version of the August 31st, 1994 article concerning the Georgia concert dates without objection. 2. Request to exclude certain evidence. A. Prior conduct of witnesses. The government moved to preclude the defendant from eliciting testimony or other evidence and from making arguments about any victim witness's past sexual behavior with anyone other than the defendant or with others at the defendant's direction. The defendant did not move under Rule 412C to introduce such evidence, thus the request was granted. So they're basically saying that because R. Kelly didn't file a motion, that she granted the request by the government that would preclude them from introducing any evidence about any of the victims or alleged victims or witnesses. B. Witnesses' mental health histories. The government moved to exclude evidence of the prior mental health histories of certain witnesses. The details were submitted under seal. The motion was granted. Although evidence of a witness's psychological history may be admissible when it goes to his or her credibility, the crucial inquiry is the nature of the infirmity and whether the witness suffered from the problem at the time of the events to which the witness is to testify, so that it may be affected the witness' ability to perceive or to recall events or to testify accurately. And then she quotes United States versus Wilson from the Eastern District of New York, which was heard in 2006, and nothing in the parties' submission showed that any witness' mental health history implicated that witness' ability to perceive or recall. Okay. C. Evidence about the victim's parents. The government moved to preclude the defendant from introducing evidence that the parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with him. This request was granted in part and reserved in part for trial. At the August 3rd, 2021 hearing, the government represented that it did not intend to call any of the witnesses' parents because a parent could not consent to the charged conduct. Questions to victim witnesses about whether their parents consented or permitted the defendant to have contact with them would have been improper. However, questioning with a good faith basis about a coordinated extortion scheme was permissible, including for impeachment. D. Evidence of the defendant's prior good conduct. The government moved to preclude the defendant from introducing evidence of his prior good conduct, including evidence of music awards or honors. Decision was reserved for trial, at which the defendant did not put on character evidence. Although criminal defendants may present evidence of a relevant character trait or reputation testimony, that evidence may not take the form of specific prior act evidence or evidence that the defendant did not commit bad acts on prior occasions. And then she goes to United States versus Enos, which was heard in the Eastern District of New York on December 20th, 2019. Any character evidence must be presented in a permissible form under these rules. Specific prior acts, including award or honors received, are not generally admissible. At trial, some witnesses testified about the defendant's professional achievements. I ruled that defense counsel's questions about celebrities' presence at the defendant's recording studio were permissible to support the defense's argument that certain conduct and protocols the government had elicited testimony about were attributable to security needs. E. Evidence of Jane Doe No. 8's employment as an exotic dancer. The government moved to preclude the defendant from asking Jane Doe No. 8 whether she worked as an exotic dancer years after her encounter with the defendant, or about her participation in a lawsuit against the owner of the exotic dance establishment for unpaid wages. The request was granted. And then she has a note here that says, at trial, defense counsel asked some of the witnesses questions along these lines. Defense counsel asked a witness about her parents' efforts to get the defendant to engage in business endeavors. Okay, then she continues. She says the evidence was inadmissible. It was not relevant to or probative of Jane Doe No. 8's truthfulness. See United States versus Davis, which was heard in California on June 27, 2007, precluding evidence that government witness worked as an exotic dancer because nothing about the job connotes veracity or a like thereof. And I don't think Jane Doe No. 8 testified, did she? So then, number 3, identities of victim witnesses. The government moved to protect the identity of certain victim witnesses during the trial. Specifically, the government sought an order, 1, permitting these victim witnesses to testify using a nickname or their first name, 2, limiting references to each in open court to their nickname or first name, and 3, preventing public disclosure via cross-examination or otherwise of their respective addresses, names of family members, or exact place of employment. The government requested that these measures apply to the following victim witnesses: Jane Doe No. 2, which is Stephanie. Number 3 was Sonia Crazy Ass. Number 5, Ariel. Can't remember who number 8 was. I think 10 and 11 was Kate and the deceased friend. 13, 15, Addie. 16. Who did we decide was 16? Was that Dominique? 17 was Juice, I think. 18 was Hallie. 20, Lisa Van Allen. John Doe No. 1 was Richard Arline. John Doe No. 2, what was his name? Alex. And he was crazy as hell too. His testimony should have been thrown out because he might have been high. The defendant did not object to the request with respect to any victim witness except for Ariel Clary. The government's request was granted. The Sixth Amendment Confrontation Clause protects two primary interests: the defendant's need to investigate a witness and to elicit information that might be relevant to the jury's conclusions about the witness' credibility or knowledge. United States versus Marcus, which was heard in the Eastern District of New York, January 31st, 2007. Citing United States versus Marty, which was heard in the Second Circuit in 1970. The government must provide a reason for the limitation it seeks, and the defendant then must demonstrate a particularized need for disclosure. The court weighs the defendant's need against the risk to the witness. United States versus Bennett, Second Circuit, 1969. United States versus Cavallaro, Second Circuit, 1977. The government identified legitimate and compelling reasons for Ariel Clary to testify using a pseudonym. Ariel Clary was expected to and did testify in explicit detail about degrading and humiliating treatment. Order on motions in limine, United States versus Martinez, from Eastern District of New York, December 18, 2017. The trial garnered a lot of media attention, and there was a significant risk of humiliation and reprisal. And that was a case from 1931. The reason to limit identifying information about a witness may be that she may be subject to reprisals. Okay, but the girl... Anyway, the defendant argued that identifying Ariel Clary publicly and by name would be necessary to his in-court and out-of-court investigation of her and goes to the heart of her credibility. He further argued that permitting the limitations the government requested would undermine the presumption of innocence. These arguments are unavailing. The defendant did not identify a clear, particularized need to have Ariel Clary's name disclosed publicly. The defendant knew who Ariel Clary is and investigated her background, nor was there any need to disclose Ariel Clary's identity in order to impeach her. Defense counsel did a thorough cross-examination of Ariel Clary about her prior statements without disclosing her name. Finally, the court gave the jury an instruction that the use of nicknames or pseudonyms is common in cases that have garnered media attention. Marcus, 2007, granting application for witnesses to testify using their first names only, and explaining that the court will instruct the jury that this is due to the sensitive nature of the conduct the witnesses will describe and the likelihood of embarrassing publicity. In sum, a balancing of the risks to the victim witnesses against the defendant's interests supported permitting the requested limitations. The victim witnesses testified about humiliating and explicit acts of abuse, some of which took place when they were minors. Conclusion: for this reason, the motions in limine were granted in part and denied in part. So ordered, and Donnelly, United States District Judge, November 4th, 2021. So there you have it, guys. Those are her reasons for denying the motions in limine that were provided. And as I stated in the beginning, that all of those motions that I told you all about that were filed under seal by Kelvin Scholar, she had already denied those as moot. So she doesn't have to give an explanation, because the explanation is they were irrelevant and had already been dealt with in her prior responses and decisions in the case. So that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.